I now turn to the fifth judgment being handed down by the court today. That is in the case of the Queen on the application of BF Eritrea against Secretary of State for the Home Department. I should again explain that the court has ordered that no one shall publish or reveal the name or address of the respondent BF, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the respondent in connection with these proceedings. This appeal is again concerned with judicial review of policy documents issued by the government. It was heard by the same panel of justices as the appeal in the case of A and Secretary of State for the Home Department, which is also being handed down this morning. That judgment sets out the principles which govern in this area. This judgment applies those principles in the circumstances of this case. This appeal is about the lawfulness of a policy issued by the Secretary of State dealing with the treatment of asylum seekers who claim to be unaccompanied children, where there is an issue about their true age. Legislation draws a distinction between adult asylum seekers and asylum seekers who are children. Adults are liable to more restrictive and less favourable treatment than children. Adults may be subject to detention while their claims for asylum are scrutinised, and children are able to access child services provided by local authorities. Therefore, adult asylum seekers have an incentive to claim to be children when they are not. It can be difficult to tell whether an individual is an older child or an adult, so there is always the possibility for mistakes to be made. Local authorities have detailed procedures in place involving experienced social workers to make the relevant judgment, but those procedures are not available in the initial phase when an asylum seeker first presents to immigration officials. Those officials have to make the judgment themselves. They may have to decide in circumstances where the asylum seeker is carrying no documents and no other evidence is available than the appearance and demeanour of the individual. The Secretary of State issued a policy to give guidance how immigration officials should approach that task. The relevant part of the guidance states that an asylum seeker would not be accepted as being under 18 if, I quote, their physical appearance stroke demeanour very strongly suggests that they are significantly over 18 years of age and no other credible evidence exists to the contrary, end quote. So a certain benefit of the doubt is given to try to reduce the risk that a person who is really a child is treated as an adult and is made subject to detention when they should not be. There is further protection in that two immigration officials must separately come to this view. However, the respondent in this case, known as BF, challenges the lawfulness of this policy on the grounds that it still leaves scope for errors to be made and for children to be detained when they should not be. That risk could effectively be eliminated if the policy directed officials to accept an asylum seeker's claim to be a child unless they considered them to be aged 23 or 25 or so. BF argued that it was incumbent on the Secretary of State to frame her policy in this way to ensure that children are not detained. BF is a national of Eritrea who arrived in the UK and claimed asylum. He said he was a child aged 16, but was assessed to be an adult by immigration officers following the policy and was detained. A first local authority age assessment carried out later seemed to confirm that he was an adult, but that was challenged and a new local authority assessment concluded that he was a child who should not have been detained. The Court of Appeal accepted BF's submission and quashed the policy. The Secretary of State appeals to the Supreme Court. This court unanimously allows the Secretary of State's appeal. As decided in the judgment in the A case handed down today, the main obligation in issuing a policy is to ensure that it does not mislead officials about what their legal duties are. The policy in this case does not mislead officials. The obligation of immigration officers is to apply the relevant statutory rule to the best of their ability on the basis of the information and evidence available to them. The policy does not misdirect immigration officials regarding their legal duty. On the contrary, it reinforces the rules set out in the statute that officials should treat the cut-off point for the difference in treatment as 18 years old. A policy which said that an individual should be treated as a child, even though officials believed that they were an adult aged between 18 and 23 or 18 and 25, would conflict with that duty. The court holds that the Court of Appeal erred by applying a different standard of review to the effect that the Secretary of State, by her policy, had to eliminate any possibility of mistakenly treating a child as an adult. That is not a viable or appropriate standard and is not the relevant test of lawfulness of a policy. The court concludes, therefore, that the Secretary of State was entitled to issue a policy drawn up in the way that she did.